Shall we start?
Okay,
Uh,
sure thing.
okay. Good morning, class. Good morning, Prof. Chen Siyuan, who are attending this class already. We are very welcome, Miss Professor Chen Siyuan, for this class, and it will be the second class, and I hope it will be a good chance for us, as it is then a good opportunity for all us also to hear the criminal law in the perspective of Singapore. So I would like to welcome you to invite you to ask questions at the end of the class. So please, the class for the question you have to hold on until the end of the class. Yeah. You would like to write at the comment. Prof. Chen Siwan, the floor goes to you until 9:10. Thank you.
Right, thank you very much. So welcome again for those of you who also attended the previous class. Today we will be looking at, as you can see from the slide, the examination of criminal cases in court. Just to make sure that everyone is on the same page, I'll briefly recap, briefly talk about what we covered in the previous class. We looked at how in Singapore there are different sources of law. So at the very top, we have the Constitution, followed by statutes, which will be your written codes. And then we have common law, which will be the decisions by the Singapore courts. So in criminal cases, we do have statutes that govern criminal law cases. Last week, we saw one example being the Criminal Procedure Code. The main piece of legislation we'll be looking at today would be the Evidence Act. So what's interesting about both of these statutes is that originally, Singapore being a former colony of the UK, we had our criminal laws and procedural laws taken from England. So, for example, our penal code, it was written in the 1800s, 1871, where we imported the penal code from India, which was also another English colony. Our Evidence Act, written in 1893, was taken from India around that time. Likewise, for our Criminal Procedure Code, originally it was taken from India. So out of these three pieces of laws, the Penal Code, the Criminal Procedure Code, and Evidence Act, it is only the Criminal Procedure Code in which the Singapore government has decided to repeal it and write our own Criminal Procedure Code. So it's an original piece of legislation. But for the Evidence Act, as well as the Penal Code, we have not really changed that much. So imagine it's a law that was written in the 1800s and hasn't really changed much in the last 120, 130, 150 years. Last week, we also saw how, because Singapore is a common law jurisdiction, it still has many elements that are quite traditional in that it's still an adversarial system. In other words, if you have a good lawyer, it really helps your case a lot. If you don't have a good lawyer, it's harder. It's much harder because the judge is not supposed to help either side. The judge is supposed to just listen to the arguments made by the lawyers and to look at the evidence presented by the lawyers. The judge is not supposed to go out of the way to find evidence for the parties. The judge is not supposed to go out of the way to think about what are the correct legal arguments. We also saw that at the same time, when it comes to matters of evidence and procedure, there is this tension between whether or not judges should just be applying rules as they are written, whether in the Criminal Procedure Code or in the Evidence Act, or do they have a fair bit of discretion? In other words, can they sometimes apply the rules a bit more flexibly, right, so that they can achieve the interest of justice or a fair outcome in each case? Next, we saw how there is also this tension between crime control and due process. So the Singapore government, for the longest time, has always been a firm believer that one of the most basic human rights a person should have is to be basically a right to safety, right? So Singapore is well known to be tough on crime, and we see that in a variety of ways. We see that in the tough and strict penal laws that we have. But for our purposes, we also see how, in matters of procedure and evidence, the courts tend to interpret rules in such a way that it would be, in a sense, easier for the prosecution to prove their case and harder for the accused to avail themselves of their due process or rights. So last week specifically, we looked at statements, which would usually be taken before an accused person is going to turn up in court and be tried. So those statements will include confessions by the accused persons. We saw how in the taking of statements, you need to adhere to certain procedural requirements, such as requiring the accused person to understand the statement that he or she has given, to sign it, and so forth. We also saw how in statements, the accused needs to have given them voluntarily. So if you threaten the accused or if you subject the accused to some sort of torture, then the statement will not be considered by the court to be legitimate and will be excluded. So today we'll be looking mainly at the rules that apply during the trial itself. What are some of the main rules of evidence that apply once an accused person has been charged and is brought to court to face trial? So perhaps the best starting point is burden of proof and standard of proof. These are ideas that you might be familiar with, but the terminology that is used in Singapore may be a little different. So in Singapore, burden of proof is also known as the legal burden. It refers to which party has to prove the case. If it's a civil case, it is a claimant or the plaintiff who has to prove the case, and for the defendant to disprove the case after the claimant has done so. For criminal cases, it is the prosecutor or the state who has to prove the case. Standard of proof in Singapore refers to how convinced the court must be. So in Singapore, as mentioned last week, there are two standards of proof. One is the balance of probabilities. The other is beyond a reasonable doubt. Balance of probabilities, also known as preponderance of the evidence in the US, for instance, refers to this idea that the court needs to be more than 50% sure. Okay, so this really applies mostly in civil cases. Criminal cases, beyond a reasonable doubt, no one really knows what the percentage is, but everyone agrees that it is more than balance of probabilities. So you contrast this with how, for example, in the American legal system, they have up to 5 to 6 different standards of proof. They also have, for instance, the standard known as clear and convincing evidence. So that is somewhere between balance of probabilities and beyond a reasonable doubt. But we don't have that in Singapore. We only have 2 standards of proof. Having said that, from time to time, the courts may also talk about a prima facie case, or they may also talk about evidential burden. Prima facie case usually applies to interlocutory proceedings, and that is before the case completely goes to trial. Right? So the court needs to be convinced that there is some proof. So it's less than balance of probabilities. As for evidential burden, this one is a little tricky to explain in a short seminar like this, but essentially it refers to the idea that in criminal cases, if the prosecution has the legal burden of proof to prove the case beyond a reasonable doubt, what then is the burden that is on the accused? If the accused does not raise a defense, then to be acquitted, what the accused needs to do is to raise a reasonable doubt. Right? As to what a reasonable doubt is, well, it's always going to depend on the facts of each case. What's interesting about Singapore also is that because of the crime control model that it subscribes to. This affects how much proof needs to be provided before the court is willing to convict. When it comes to circumstantial evidence, for instance, the court is completely okay convicting using only circumstantial evidence. And what is circumstantial evidence? Circumstantial evidence would be evidence that does not prove something directly. So imagine we have a crime scene, okay? And at the crime scene, we see maybe bullet shells, we see the marks of shoes, we see blood. So all these things do not directly prove that a crime has taken place, but they indirectly show that a crime has taken place. And in Singapore, it is completely possible to convict using only circumstantial evidence. This is quite uncommon in common law jurisdictions, right? Whereby usually they expect you to prove a case having some direct evidence. So that's the point on circumstantial evidence. And the related point is on corroboration. Corroboration means, do you have additional evidence to support the main evidence? So imagine that the crime is this. The crime is someone accuses another person of outrage of modesty, right? In some places, we call it molestation. And the only evidence that we have is the complainant, the victim, plus the accused. The victim says, you touched me illegally. The accused says, no, I did not. So if you only have these two pieces of evidence, it's very hard to tell who is true, right? So of course, you could subject both parties to cross-examination, assuming that the accused is willing to testify. But in Singapore, it is possible to convict using just the evidence of the complainant and there not being any other evidence. So in Singapore, we do not have any rules on corroboration. Okay, so I think this is another example of how crime control is really the main priority in Singapore. So under the Evidence Act, in terms of the burden of proof, the starting point is found in sections 103 and 104. So this one is quite straightforward. There's nothing controversial there. But things become a bit more complicated when we look at section 3. So here I provided the definition of what proof means. Okay, it's quite a long sentence, but it refers to this interesting idea about what a prudent person would decide under the circumstances of the case as to what the standard of proof is. So remember earlier I said that the Evidence Act was brought into Singapore in the 1800s. Despite that, subsequent cases have interpreted Section 3 to mean that there are only two standards of proof found in Section 3. As mentioned, it will be balance of probabilities and beyond a reasonable doubt, even though the idea of a prudent person under Section 3 seems quite broad. So the courts have therefore taken the view that there is actually no such thing as an evidential burden within the Evidence Act. And why is that important? Because, for example, if you look at Section 107, it says that if a person has been accused of an offense, the burden of proving the existence of the defense is on the person. So here you have two situations. In situation 1, the accused does not raise a defense, right? So let's say you charge the accused with a crime and you ask the accused, what do you want to say? And the accused says nothing. The accused says, I want to keep quiet. I'm not going to say anything. For the prosecution to succeed, the prosecution must prove the case beyond a reasonable doubt. But for the accused to succeed, to be acquitted, he only needs to raise a reasonable doubt. So if we imagine for a moment that proving a case beyond a reasonable doubt is something like having the court believe your case at least on a 70% level, the court must be 70% convinced. Let's just assume, right? Because we don't really know what the number is for beyond a reasonable doubt, other than how it's a higher threshold than balance of probabilities. What this means then is that for the accused to succeed, the accused needs to raise a reasonable doubt. So let's say the court just needs to be more than 30% sure that the accused is correct. That is the first situation whereby the accused chooses to keep quiet. But based on Section 107, based on how the courts have interpreted Section 107, if the accused raises a defense, so he's not keeping quiet, he's raising a defense. So going back to our earlier example about a complainant who says that she was touched inappropriately by a person, right? So outrage or modesty or molest. And this person, instead of keeping quiet, says, "Oh, I think it's an accident. I didn't mean it." So the moment he says that, that is a defense under the penal code. And to be able to prove this defense, he must be able to prove it on a balance of probabilities. It is no longer enough for him to raise a reasonable doubt. So what does this mean? It would seem that it would be better for the person not to raise a defense, right? Because if you raise a defense, suddenly you need to prove your case on a higher standard of proof than if you chose to keep quiet. And this is where we go back to what we looked at last week, whereby during the taking of statements, the accused person is incentivized to outline any defense that he is going to rely on at an early stage. If the accused only raises a defense at trial or at a later stage, this may affect his credibility. This may result in adverse inferences. So again, this is another demonstration of Singapore's crime control model. But it's not just Section 107 that perhaps derogates from a presumption of innocence. We also have Section 105, particularly illustration B. There it states, a person wishes the court to believe that at the time in question, he or she was elsewhere. That person must prove it. This is otherwise known as alibi. Right? Alibi just means you couldn't have committed the crime because you were somewhere else. And so Section 105 says that if you want to rely on such a fact, you must prove it. And what does prove it mean? Within the meaning of the Evidence Act, it means that you need to show on a balance of probabilities that you have an alibi. So I don't know if you can see the tension here. In a criminal case, the prosecution is supposed to prove the case beyond a reasonable doubt, right? But yet, when it comes to an alibi, it is for the accused to prove on a balance of probabilities. Suddenly, the accused has a higher standard of proof to discharge. So it's no longer just raising a reasonable doubt. They must positively prove it. So just like a defense, it may seem that it's better for the accused not to plead an alibi, because if they decide to plead an alibi, for them to succeed, they need to satisfy a higher standard of proof. But what's interesting is that even though for Section 107, the courts have been then consistent to say that if you want to prove a defense, it needs to be on a balance of probabilities. When it comes to Section 105, the courts do not take the same view. The Singapore courts say that, oh, for 105, even though the provision says you must prove an alibi, this doesn't mean that you have a legal burden of proof. It just means that you can still raise a reasonable doubt. So that's interesting to me because in many other instances, as we have seen in previous class and today's class, the courts have been fairly supportive of crime control. But here, for Section 105 at least, they say that, you know what, for alibis, you don't need to prove it. You just need to raise a reasonable doubt. And I think this is partly because when it comes to alibi, it overlaps with the prosecution's case to a greater degree. Because if a person has an alibi, unless it's a remotely controlled crime, the person couldn't have committed the crime. And finally, we have Section 108 of the Evidence Act, where it says that where there is any fact, especially within the knowledge of any person, the burden of proving that fact is upon that person. So here we also see the same phrase, burden of proving. But despite this phrase having been interpreted as a positive duty to prove something on a balance of probabilities, the courts have consistently held that Section 108, just like Section 105, only creates an evidential burden. Because if you take Section 108 literally, it would seem that as long as something is especially within the knowledge of someone, that person has to prove it. So we go back to the example of the accused who has been charged with outrage or modesty. Is there any person in a better position than the accused to talk about whether or not he or she committed the crime? Wouldn't this fact be especially within the knowledge of that person? So the literal scope of Section 128 would perhaps be too jarring a derogation from the presumption of innocence, because here you're now expecting the accused to prove his case when the presumption of innocence means that it is for the prosecution to prove their case beyond a reasonable doubt. So in my view, for sections 105 and 108, these are examples of the courts, the Singapore courts, trying to calibrate the presumption of innocence. So even though in the Singapore legal system, the constitution is at the top, the statutes will be next, and the common law follow the statutes, it is true that the courts cannot rewrite either the constitution or the statutes. But what the courts can do is to interpret the statutes or the constitution in a way that is more consistent with principles. So your rules are one thing, but the principles that govern the rules are another. So the principle that will be at play in criminal proceedings will therefore be the presumption of innocence. So on the one hand, under Section 107, the courts say that for defenses, you need to positively prove it. But on the other hand, for alibis, for special knowledge, the accused does not have the legal burden. Apart from the penal code, we have many other statutes that create criminal laws. One such example would be the Misuse of Drugs Act. As mentioned last week, Singapore takes a very stern, tough approach to the regulation of drugs. So under the Misuse of Drugs Act, we see a couple of presumptions. Under Section 18.2, any person who is proved or presumed to have a controlled drug in his possession is presumed to have known the nature of that drug. And then you have Section 17B, also of the Misuse of Drugs Act. Any person who is proved to have in his possession more than 2 grams of diamorphine is presumed to have that drug in possession for trafficking. So how do these presumptions work? So imagine, if you've ever been to Singapore, imagine you visit Singapore, Changi Airport, right? That's the main airport that we use. And let's say a person is found with 2 grams of diamorphine in his possession. 2 grams is not a lot. But in Singapore, more than 15 grams, you might get a death penalty. Anyway, imagine someone is found with 2 grams of diamorphine. And this person says, I do not know how come I have this drugs on me. This wouldn't work under the Misuse of Drugs Act, because the Misuse of Drugs Act creates 2 presumptions. The first presumption under 18.2, the first bullet point, is that if you are caught with drugs, you are presumed to know that you have drugs and that you know what the drugs are. So you can't just say, oh, I was told to carry this white powder, but I don't know what it is. You cannot say that. The Misuse of Drugs Act creates the presumption to say that you know what the drugs are. The second presumption is that you also cannot say, oh, these drugs are for myself. They're just for my own consumption. I'm not trying to traffic drugs. I'm not trying to sell them. Under Section 17B, the second bullet point of this slide, you are presumed to be trafficking those drugs. So this, I think, is the most emblematic, the most illustrative of Singapore's approach towards drugs and drug trafficking in particular. But keep in mind that these are presumptions, which means that you can rebut those presumptions. You can rebut those presumptions if you can produce proof to show that you did not know the nature of the drug or you did not intend to traffic the drug. And the standard of proof that you need to discharge is known as balance of probabilities. Okay, so it works just like a defense. Now, there may also be questions as to whether such presumptions are legal, right? Because remember, in Singapore, Constitution is at the top, then statutes like the Misuse of Drugs Act. So if a statute does not follow the Constitution, the court can declare it to be unconstitutional. But so far, multiple challenges that have been brought to the Singapore courts to declare the Misuse of Drugs Act unconstitutional, they have all failed. There have been many, many challenges since the 1960s, and they have all failed. However, this doesn't mean that the courts just accept the validity of the statute. In other statutes that also create presumptions, the Singapore courts would take two approaches. One approach is to just look at the statute on its face and see whether or not it is obvious what the accused needs to do. The other approach is to take a more object and purpose-based approach. So what I mean by that is, one big reason why the Misuse of Drugs Act has never been struck down as being unconstitutional is because the Singapore courts take the view that the combating of drug trafficking is a national imperative in Singapore. It's a very important goal. It's a very serious crime. In the Singapore courts and the government's view, drug trafficking destroys society. It destroys families. And so the Singapore government takes an all-out approach to wipe out drug trafficking. And so even though the Misuse of Drugs Act is quite harsh because it creates those presumptions, and it's also very harsh in terms of the potential penalties. Like I said, you could get a death penalty for drug trafficking, even just for 15 grams. That's one of the considerations. If it's a very serious crime that you're trying to combat, then it is easier to justify the presumptions. On the other hand, if the crime is not so serious, then it is possible that the law may be read down, right? The courts may declare a statute to be either unconstitutional or that they should be interpreted differently. In other words, the presumptions perhaps do not create legal presumptions. Now, has there been any statute that has been read down by the Singapore courts for being unconstitutional? As far as I can tell, never succeeded, right? So either the statutes are so well written that they just can't be unconstitutional, or that perhaps the Singapore courts also take the view that crime control is the right way to go. Now, I've mentioned a few times that the things could be struck down for being unconstitutional, and you may be wondering, okay, what in the Singapore Constitution might allow the courts to say that a statute is unconstitutional? So there are usually three arguments that will be made. The first argument is that the statute violates some idea of fairness and justice. The problem is that under the Constitution, it is very explicit. It doesn't talk about fairness and justice in very abstract or broad terms. It talks about a right to a fair trial. So one then has to make the argument that somehow legal presumptions might compromise a fair trial. But the reason why the fair trial argument doesn't work so well is because fair trial really means what happens in court rather than whether or not a law is well written. Then the second argument that is usually advanced is that there has been a violation of equality. And how this may arise, imagine you have two people, they're part of the same gang. They're both trying to traffic drugs into Singapore. Both of them are caught. Both of them are caught with the same amount of drugs, right? Each of them are caught with, say, 100 grams. That's a lot, but let's assume that's 100 grams each. So definite death penalty if it's something like diamorphine. But what the police usually would do is to try and divide and conquer, right? They will try to make one of them testify against the other. And in return, they may promise the person who cooperates a lesser charge. So instead of charging the person with 100 grams, which would definitely carry a death penalty, the prosecution decides to charge them only with 10 grams, which wouldn't carry the death penalty. But for the other person, because they want the other person who has been uncooperative to receive the death sentence, they'll charge him with 15 grams, 100 grams. Anything above 15 grams will be death penalty for diamorphine. So this is a potential violation of the equality clause under the Constitution because you have two people committing the very same crime at the same place, but only one of them is getting the death penalty. But the Singapore courts have held that there's nothing wrong with this because it's really about, is there any reason for the differentiated treatment? And if the reason is you want to be a bit more lenient to the person who is cooperative, that's considered an okay enough reason. The third argument that is usually advanced to say that the Misuse of Drugs Act is unconstitutional has more to do with the penalties. So they might say that the death penalty is a violation of human rights, it is torture, inhumane treatment, and whatnot. All of these arguments have never worked. So one thing you may not know about Singapore is that, or maybe you know, is that we don't really sign on to human rights conventions. So the International Covenant of Civil and Political Rights, the International Covenant of Social, Economic, Cultural Rights, Singapore has not signed on, right? So because of that, we do not have the same human rights obligations as many other countries. So the two conventions I just mentioned, the ICCPR and ICESCR, I believe they have more than 150 states each that have signed up. And how many states are there in the world? Around 200, right? So the great majority of states have signed on to these human rights treaties, but Singapore have not. And I think that's part of the reason why our courts conclude that there's nothing wrong with the death penalty, right? And in Singapore, we also have caning. We also don't think there's anything wrong with that. Okay, so that's for burden of proof and standard of proof. Now we come to similar fact. What is similar fact? Let's go back to the example of the person who has been accused of outrage or modesty, right? Committed on, let's say, the metro, the subway. Earlier, I also talked about how sometimes in certain crimes, you have no other witnesses. You only have the accused or the complainant, no corroboration. But what if the prosecution is trying to adduce certain evidence that shows indirectly that the accused may have committed a crime? So let me give you a few scenarios. Scenario one, there is evidence of the accused having attempted to commit outrage or modesty on the same victim before. Are you more likely to believe that the accused is guilty? Scenario number two, the prosecution has evidence that, say, 10 years ago, the accused person tried to molest other people before. Does that convince you? Or scenario number three, the accused is just a bad person, right? He is very rude. He is known to be violent. He is just a problem for society. So the similar fact rule is referring to situations like this. To what extent can you refer to a person's past behavior to prove that he committed a crime in the present? And in other common law jurisdictions, they may not use the label similar fact. The similar fact label really came from the English in the 1800s. It persisted to around 1980s or 1990s. Since then, places in the UK and Australia, New Zealand, they refer to similar fact as character evidence, or they refer to it as coincidence evidence or tendency evidence. But the idea is the same. Can you use a person's past behavior to prove present behavior? So under Section 14 of the Singapore Evidence Act, it states that facts that show the existence of any state of mind, right, are relevant when the existence of any such state of mind is an issue. Not that straightforward what it means, right? So the illustration is quite helpful. Imagine that a person is tried for the murder of another person by shooting the person dead with intent. The fact that this person, on other occasions, shot at the same victim is relevant to show that he had the intention to shoot the same victim in this case. But the fact that this person is in the habit of shooting at other people, not this person, okay, that will be irrelevant. So section 14 illustration O would suggest that if you want to adduce similar fact evidence, it must be highly specific for you to be able to legitimately draw an inference that the present conduct can be proven. So if you go back to the three scenarios I pointed to earlier for the molestation case, the third scenario of this person just being generally a nasty person, a rude person, a violent person, you can't admit it under section 14. The second scenario in which the accused has 10 years ago been accused of molesting someone else also wouldn't pass under section 14. But the first scenario in which the accused has previously tried to molest the same victim before, that may perhaps be admissible under section 14. But one other limitation about section 14 is that not only do you need a high degree of specificity in past conduct, you can only use section 14 to prove mens rea. So mens rea is the mental element of the crime. You cannot use section 14 to prove actus reus. So let's say in the example of the person being accused of molesting, if he denies even touching, then there's no actus reus. So you can't use section 14 to prove that he did commit the actus reus of the crime. On the other hand, if he admits to the physical act, but he denies the mental element, he denies intent, then section 14 can be used to prove that the past conduct could indirectly show he committed the present conduct. So that's for section 14. The other relevant provision in the Singapore Evidence Act is section 15. So it states, when there is a particular question whether an act was accidental or intentional, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. So again, it seems like a rather technical expression. What does section 15 mean? What do you mean by this? And to understand that, we need to look no further than illustration A of the same provision. And just like section 14, it sets a pretty high threshold. It tells us that a person is accused of burning down his house to obtain money for which it is insured. So in other words, insurance fraud. The fact that A, this person, lived in several houses successively, each of which he insured, each of which a fire occurred, and after each of which he receives payment from a different insurance office, are relevant as showing that the fire was not accidental. Okay, so you want to refer to similar acts in the past, you can. But under section 15, you need a series of similar occurrences. And it's not just a series of similar occurrences. Based on the illustration, the occurrences must be quite similar. Okay, and just like section 14, you can only use this provision to prove mens rea. You cannot use this provision to prove actus reus. But just like section 14, it is not so easy to use this provision, right? It's a high threshold, it's a high bar to admissibility. What's interesting, however, is that even though I mentioned twice that the Evidence Act does not allow you to admit similar fact to prove actus reus, right? Because 14 and 15, they only cover mens rea. The Singapore courts have held that if you want to admit similar fact to prove actus reus, you can. You can do it under section 11B of the Evidence Act. And in that provision, we are told that facts not otherwise relevant are relevant if by themselves or in connection with other facts, they make the existence or non-existence of any fact and issue or relevant fact highly probable or improbable. Again, it seems like a very technical provision. What does this mean? In short, it means that if the accused denies the crime, you can use Section 11B to rebut whatever he is saying. Now, what's the problem with this? The problem with this is that that's so incredibly broad. It means that as long as the accused is denying something, you can use Section 11B to rebut him. The reason why I say this is too wide is that this was probably not the intended design of Section 11B, right? Especially if the evidence that you're using is going to infringe on the similar fact rule, then all the more Section 11B is not meant to be used this way. So what was the purpose of Section 11B? Now, it's a bit unclear because in many other common law jurisdictions, they do not have statutes with such a wide category, right? What we call a general relevancy provision. But I suppose to the extent that the Singapore courts have ruled that Section 11 can be used this way, then that is further evidence of how the Singapore courts subscribe to the crime control model. Because at the end of the day, it is really the prosecution rather than the accused who will be admitting evidence. As the accused generally would want to keep quiet if they can help it, right? Subject to whatever adverse inferences that may be drawn. And the accused will generally not have access to all the evidence. So it's really the prosecution who will be trying to admit evidence, because after all, the legal burden of proof is on them, and the higher standard of proof, which is beyond a reasonable doubt, is on them and not the accused. So what's also interesting is that the Singapore courts, right, in certain situations, they prefer not to apply the Evidence Act because Section 14 sets a high bar. Section 15 sets a high bar. Section 11, not really supposed to be used for similar fact, but they do it sometimes. But what the Singapore courts have done, in addition, is to adopt the English position on similar fact. What is the English position on similar fact? And when I say English position, this is a position that has actually been abolished in England since, I think, sometime in the 1970s, right? So around 50 years ago. The English position, when it comes to deciding whether similar facts should be admitted, is a very simple test. You just ask yourself, does the probative value of the evidence outweigh the prejudicial effect? Probative value means, what does this evidence prove, right? Prejudicial effect. So courts and scholars have struggled with this question for decades. What do you mean by prejudicial effect? It's a term that you will come across quite often in the common law context. You will come across it in criminal law, you come across it in criminal procedure, you come across it in civil procedure, you come across it in evidence law. And after decades of struggle, this is what the courts have concluded. Prejudicial effect means the opposite of probative value. So when you are doing a weighing exercise of whether there's probative value that outweighs prejudicial effect, what you really mean to say is, does the evidence prove anything? And I don't know whether it's obvious to you, but this is again an incredibly broad and facilitative test. Right? To ask the question of what does this prove is too simple. It's too low a bar. So pretty much anything would be proving something. Right? And this is a consequence of ignoring the Evidence Act and instead relying on the common law rules. So again, the Constitution sits above the Evidence Act. The Evidence Act sits above the common law rules. So the courts, if one were to be proper and legitimate, should not be applying common law rules if they contradict the Evidence Act. But yet that's what the courts have done over and over again. Instead of applying the Evidence Act, they just apply the common law test of probative value versus prejudicial effect, which again is just another way of saying, what does this evidence prove? There's no bar, there's no threshold at all. Anything goes. And I suppose it should be of no surprise to anyone now that my conclusion as to why this is done is that the Singapore system really believes in crime control, because it is really only the prosecution that will be admitting similar fact, right? Because the defense would not want to admit, or rather would not really have any evidence to admit. On this point, let me just make a brief detour. If the prosecution can admit similar fact, can the accused do so? The answer is yes, but usually they wouldn't want to do it because similar fact tends to be incriminating. There is, however, a provision in the Evidence Act that talks about good character evidence. So under that provision, if you want to look at it, it's in sections 54 to 57 of the Evidence Act. Under that series of provisions, an accused person can adduce good character evidence. In other words, they can produce evidence to confirm that they are good citizens, responsible citizens. But if they do use that, if they do use that provision to admit good character evidence to show that they did not commit the crime, under section 122, this allows the prosecution to admit any kind of evidence against the accused. Any kind. So bad character evidence, similar fact evidence, anything goes. There are no longer any limits. In other words, there is absolutely no incentive for the accused to ever want to admit good character evidence. And for reasons mentioned, similar fact evidence as well. So I had just talked about how the courts have ignored the Evidence Act and used a more flexible common law test of probative value and prejudicial effect. But there's also the question as to whether or not that test, right, PVPE, probative value prejudicial effect, is that a discretion that the court has, or does that replace the Evidence Act? So the case law is a bit divided on this. There are cases that suggest that, oh, the probative value test is not meant to replace the Evidence Act. You're only supposed to apply it after you apply the Evidence Act. But that doesn't make sense because the Evidence Act has a higher threshold for admissibility than probative value versus prejudicial effect. But then there are also cases that say that the probative value test replaces the Evidence Act. But as mentioned, this would then directly contradict the terms of the Evidence Act, and that is not permitted. Lastly, perhaps the only way in which one could say that the probative value test is of any utility is to say that prejudicial effect does not just refer to the lack of probative value. What prejudicial effect could mean instead is that you can take into other considerations that don't really have to do with whether or not the evidence is similar enough. And this is not a unique or radical idea. In the UK, where the similar fact rule was first born, they have rationalized the similar fact rule to basically prevent a person's privacy and right to dignity from being violated. And what do I mean by that? Under this line of thinking, if you want to prosecute someone and you want to prove the crime, you should be finding evidence that shows that this person proved the crime. You should not be looking at this person's past, last week, 5 weeks ago, 5 years ago, 50 years ago, because suddenly this person's entire life is under scrutiny. And it's not even clear if what he did in his, before he committed the crime allegedly, is relevant to anything. So you're trying to provide the privacy and the dignity of the individual by not subjecting his entire life to judicial scrutiny. However, the Singapore courts have never explored this idea that prejudicial effect could go beyond the meaning of probative value. And so that's where we are at now. It's still a very simple weighing exercise of probative value versus prejudicial effect to decide whether similar fact should be admitted. Next, we refer to the hearsay, which is another key common law rule of excluding evidence. What is hearsay? I think most of you probably have heard the term before and may even have studied it before. This is what it means in Singapore. Give you a very simple example. Let's assume that there has been a road traffic accident. So an accident has occurred on the roads. There is a witness who saw that, okay, the person who caused the accident was driving very quickly and driving very recklessly. In Singapore, that's possible, right? Because we have highways that allow you to do that, and they're not some at certain times of the day. Uh, uh, the roads are quite free, and you can just charge down the highways. So the witness sees this, right? He saw a person who seems to be driving recklessly. And the witness tells what he saw to another person who didn't see this accident. And the original witness who saw the thing disappears. You can't find him anymore. But the person whom he told the evidence to is still around. So this is hearsay because what hearsay is concerned with is that you want to be able to have the person who originally saw the event to be cross-examined at trial. So last week I mentioned a few times that cross-examination is considered one of the most important things for a common law system because that is the main way in which the court tries to establish facts. It is not very efficient and is not always efficacious either, but that's the common law tradition, right? That you have a lawyer who would ask questions to the witness on the other side and try and make the witness produce self-contradictions and whatnot. So hearsay is very much attached to the idea that you should, as a starting point, have the right to cross-examine people who directly saw the event. But if the person who directly and originally saw the event is no longer around, then you lose that very important advantage, right? And apart from this idea of being able to cross-examine the witness, there's also this idea of a right of a party to confront the accuser. So imagine, go back to the example of the person being accused of committing outrage of modesty. Okay. Imagine if the complainant does not want to testify, right? They say that, okay, I call the police, I lodge a complaint, I give a statement to the police, but I do not want to testify. This means that not only is the accused unable to cross-examine the complainant, the accused is also unable to face the witness at trial because the person is not taking the stand. Okay, so it's this idea about being able to confront the person who is accusing you of something. That's why the hearsay rule exists. However, even though I've just given you a simple illustration of how hearsay works, the common law rules of hearsay over time have been considered way too complicated to the point that no one really understood how it works. Let me give you a couple of examples to show you how absurd the hearsay rule has become. Most of us would have a digital clock somewhere. It could be our watch, it could be our smartphone, it could be a clock in the classroom. What does the clock do? It tells you the time. But how the hearsay rule works is that if you're trying to show in a court that certain things happened at a certain time and you're trying to refer to a clock, under some of the old hearsay rules, you will not be allowed to do that. Why? Because the clock is trying to say that this is the time something took place, but you cannot cross-examine the clock, and therefore it's hearsay. Sounds pretty silly, right? Let me give you another example. Imagine that you're trying to show that a person traveled to another country on a certain day at a certain time using a certain plane. How will you try to do that? You will show the air ticket right? Of course, nowadays with CCTV, you might be able to show camera footage of the person boarding the plane. But in the past, where there was no CCTV and all you had was the plane ticket will show you what? The plane ticket will show you who was traveling on the plane, um, on what date, at what time. But there were cases under the English common law that say that no, the ticket is hearsay. Because the ticket is trying to say that a person is traveling to a certain place at a certain time on a certain plane, but you cannot cross-examine the ticket. So again, it sounds pretty ridiculous. And that is why in many jurisdictions, the courts have gone away from trying to apply the hearsay rule in its traditional way, right? Because it's not just about has someone tried to say something or has something tried to say something and can you cross-examine it? The courts have taken a much more global view, a much more commonsensical view as to whether something is hearsay. So other examples in which the hearsay rule has been considered too complicated would be in the doctrine of implied assertions. So this was based on a case in which you had a person who was seen running away from his house when his house was burning. And then there is another person who says to this person who's running away, hey, your house is burning down. Why are you running away from it? Now, what's the big deal here? It turns out that the person who was running away from the house was accused of burning down his house to collect insurance money. So when you have a person who is not trying to save the house by putting out a fire, but running away from it, the witness who said, hey, your house is burning down, why are you running away, is making the assertion that this person is doing something wrong. And because he's making an implied assertion, the hearsay rule kicks in and the court say, no, you can't admit the evidence. Then the other example is on res geste, right? The last two words on this slide. So res geste is meant to be an exception to the hearsay rule. It's a Latin term. And what it refers to is this idea of one transaction. Under the Singapore Evidence Act, Section 6, even though something might violate the hearsay rule, if you can show that the evidence was close enough in time and space, you might be able to admit the evidence. So let me give you an example. And this is based on a real case. You had a person who was minding his own business and sleeping at home, right? He's just at night sleeping at home. Someone attacks the person, okay? And the person wakes up. The person wakes up and he tries to chase the person who was attacking him. As he's chasing the person, he is suffering from the injury and he's about to die. And just before he dies, as he's chasing the person who attacked him, he tells another witness, oh, I recognize the person who attacked me. His name is X or John or whatever. And then the person who was attacked, he dies. So there's a hearsay issue because the person who originally saw the event, which is the victim, he's dead. He can't go to court and testify. But the res geste rule is an exception to the hearsay rule, which says that things that happen as one transaction can be admitted. Now, the problem is that under the common law, the question really is, how close in time and space must the one transaction be? And as it turns out, incredibly close in time and space to the point in which it's impossible. Because the common law would say that whatever that was said after he was attacked to the witness is not part of the same transaction. The common law, there's another famous case in which you had a woman who was attacked. Somebody came up from behind her and cut her neck. And as she was bleeding and dying, she told another witness who came by and said, this person cut my neck. And then she dies. The English courts held this is not part of the same transaction. Even though everything happened within 30 seconds, half a minute, the court said this is not part of the same transaction. So that's another example of how the hearsay rule was applied in a rather ridiculous way. And another reason why the courts have slowly moved away from trying to apply the hearsay rule too strictly. Then we come to this interesting case called Ratton to perhaps show you how the courts try to figure out whether something is technical or principled. What happened in Ratton? You had a husband and wife. They lived in the same home. The wife died from a gunshot wound. The hearsay evidence in question was that just before she died, there was a phone call made to the police. Well, more specifically, there was a phone call made to a telephone operator. Back then, you can't just call the police. You have to call an operator who will then put you in the line with the police. So this case is obviously quite old. So there was a phone call made to a telephone operator. And in that phone call, what was told to the telephone operator was, "Get me the police, please." But what was unknown was that it wasn't clear who called the operator. All that was known was that somebody from this particular household had called the telephone operator. So the identity of the person who said, "Get me the police, please," it was unclear. There's a hearsay issue because if the prosecution is trying to say that it was the wife who was calling the telephone operator, she's dead. She can't testify anymore. She died from the gunshot wound. So how did the courts try to think of a workaround? They had two options. The first option was to say that this is not a hearsay situation because even though the wife is dead, the telephone operator is not. Right? The telephone operator could come to court to testify and say that, yes, I don't know who called me, but I can say that I did receive a phone call from this number, therefore this house, and I can also confirm that this was what was said to me. "Get me the police, please." And I can also say that the person sounded terrified. That's the court's first option. The court's other option, which is the option they took, was to not try and stretch the hearsay rule beyond its traditional meaning, but to say, let's look at what the accused is saying first. And what did the accused say? So the accused had a couple of options. The accused could have chosen to keep quiet all the way and exercise his right to silence and privilege against self-incrimination, which he did not. What the accused said instead was that he admitted to shooting the wife, but that it was an accident. So he said that he was cleaning his shotgun, and then his wife came along and he accidentally shot her. Sounds like a convenient story, but in the circumstances, it was probably the most logical thing for him to say because there was no one else living in the house and there was no other way he could explain how the wife was shot. So he might as well just go for the defense of accident. But what the court did, this is an English case decided by the Privy Council, House of Lords, was, okay, since you raised this defense, we are going to use the operator testimony to rebut it. Okay, so you can see how this court just ignore the hearsay analysis to think about whether or not the wife is making an assertion, whether or not the wife is available to testify. I mean, she can't be because she's dead. But instead, they focused on what the accused was arguing and they used hearsay to rebut it. So this is, if you can recall, quite similar to what we saw in Section 11, whereby instead of applying the rules, the courts just take a more flexible view to things. Then there's also the interesting case of Clearly. This is also an English case. What happened here was that Clearly was a suspected drug trafficker. And his mode of operation was quite interesting. He would set up his base at home. People would call him, ask for drugs, and he would send them drugs, or people would visit him, ask for drugs, and he would give them drugs. But he was smart enough never to keep the drugs in his house. Okay? Because if you keep the drugs in your house, it is easier for the police to show that you are not just having drugs for personal consumption, but you're actually selling drugs. So what did the police do? The police raided his home. They couldn't find the drugs. But then they stayed in his home and told him to carry on his business. So while they hung around his home, clearly received phone calls, which the police were listening into. In the phone calls, they said, get me the usual. So they were using code, right? They were not making a request directly. They said, get me the usual, which is code for saying, give me drugs, right? Let's arrange a time to meet. So there were phone calls to that effect. And there were also visitors who visited clearly and also using code said, get me the usual. So in total, there were 27 phone calls and visitors, all intercepted by the police. The House of Lords held that all of this evidence of the phone calls, of the visitors, inadmissible because it's hearsay. And why is it hearsay? It's hearsay because the people who made the phone calls, the people who visited, they were not part of the trial. They were not brought as witnesses. Their accounts, the fact that they had called, that they had visited, these were accounts given by the police who were there in Kearley's home. So again, the court had the opportunity to look at hearsay not just from the perspective of whom originally made the statement. In this case, it will either be the visitors or the callers. They could instead just have looked at the police and say, okay, sure, the police were not the one who made the calls or paid the visits, but they can testify to what they heard and saw. And so there's no hearsay problem. But the House of Lords refused to do so. The House of Lords just said, you know, if you want to avoid the hearsay problem, you need the visitors and you need the callers at trial. If not, it's hearsay. So far from applying common sense, the courts took a very technical approach to hearsay, and that prevented Kearley from being convicted. There are some other cases here which you can look at, like Blasland. You can just Google Blasland and you can read the summary. That one is an even more extreme case. I wouldn't go through it so that we can keep to time. So in Singapore in 2012, we decided to amend the Evidence Act to make it much easier to admit hearsay. How easy is easy? You can look at Section 32 for the precise details, Section 32 of the Evidence Act. But for example, documents can now be freely admitted. Any kind of document. And why would a document contain hearsay? So earlier I talked about the case about a plane ticket. Technically, as long as a document is trying to make a statement about something, it is potential hearsay. But it is not insurmountable in that if you can get the person who wrote the document or who is in charge of printing the document, then you can escape the hearsay problem because you can cross-examine that person and ask questions to that person. Hey, what does this document mean? Why was this inside a document? Why was this not inside a document? But now with the 2012 amendments to the Evidence Act, you don't even need to do that. As long as it's a document, even if it contains hearsay, you can admit it. In terms of human witnesses, as long as you can show that you have tried to contact a person and you can also show that this person cannot come to court. So for example, if the person is based overseas or if the person has ran away, then that's fine. You can still use any evidence in relation to that witness and escape the hearsay rule. Let me give you an example. Suppose you have a contractual dispute. And one of the questions was, what exactly did the parties say, right, following the conclusion of the contract? Let's assume that that's a relevant fact. And one of the parties did say something quite important, but that party is no longer available. So let's say he moved to another country and he refuses to come back. So Singapore or any country for that matter will have no jurisdiction over this person, except for the country that is currently hosting this person. So under the Evidence Act, okay, if you can show that, then you can use the evidence that this was what he said. There's a clear hearsay problem because you cannot cross-examine him, but you have other evidence to show that this is what he said, then that's fine. Having said that, because the new Section 32 is incredibly permissive, the courts are now given a discretion to exclude the hearsay evidence. And the test that they are told to use is this test known as interest of justice, which to me is a incredibly broad test, because what does interest of justice mean? Isn't the court always supposed to act in the interest of justice? You mean there are situations in which they do not act in the interest of justice? It can't be. And what the courts have concluded in terms of interpreting interest of justice is that this is a multifactorial approach. They will look at things like the relevance of the evidence, the reliability of the evidence, whether the evidence is likely to mislead the fact finder. Basically, good faith and common sense. If there was no good reason why the person couldn't be produced in court and be cross-examined, then the evidence would probably not be admissible hearsay. Okay, so we have seen similar fact. That's one exclusionary rule. We've just looked at hearsay, another exclusionary rule. Next, we move to opinion, which is the third exclusionary rule found in the Evidence Act. So under the Singapore system, witnesses in court are only supposed to testify about things that they saw or heard, right? Or they're not supposed to give an opinion. So in the example of the road traffic accident, a witness can say, I saw a red car at this time at this place, and the driver seems to be driving fast. Is that a fact or is that opinion? If, let's say, the witness is able to explain what he means by fast, so let's say it looks like it's above 70 kilometers per hour, which is the speed limit in most roads in Singapore, then okay, that's not really an opinion. But if the witness says, I saw the accused driving very dangerously, but is not able to explain how. He's just saying this person just looks like he's a very reckless driver, then that's an opinion. That's not a fact anymore. And the opinion rule would therefore prevent the evidence from being admitted. But there is a big exception to the opinion rule, which is that if the opinion comes from an expert, then that may be allowed. If you're just a normal witness, probably not. Okay? And the idea here really is that in certain disputes, you need experts to help the courts to resolve difficult questions of fact. So imagine that you have a criminal case. The accused has committed murder, but the accused says that he's of unsound mind. In other words, he has a mental condition that prevents him from knowing what he's doing. So is the court able to resolve this sort of defense without help from experts? In this day and age, probably not. So they will probably need psychiatric opinions, right? Opinions from people who are medically trained in that field to give an opinion. And under the Evidence Act, this is permitted under Section 47. And just like the hearsay provision in Section 32, the court also has an interest of justice discretion to decide whether or not they want to admit the evidence. So the factors are the same as for hearsay. They'll look at whether or not the opinion evidence is relevant. They'll look at whether or not the opinion evidence is reliable, right? And to do so, they will look at, for example, the qualifications of the expert, how much experience the expert has, whether or not the expert has direct knowledge, right? Or whether the expert is more a theoretical expert rather than a practicing expert. Okay, so it's quite a flexible, broad-based test. But alongside the expert rule, there are some other rules that may also apply to limit the scope of expert evidence. So one such limiting rule is the common knowledge rule. Common knowledge rule, as its name suggests, prevents an expert from testifying about things that is already widely known. Okay, so the idea behind this is that you really only need an expert to tell you about things that you don't know. Otherwise, you can just figure out yourself, right? The court can figure out themselves, the parties can figure out themselves. You need an expert for specialized areas. So common knowledge rule means if it's something that doesn't need an expert, then the expert shouldn't testify on that. Perhaps the more interesting rule is the basis rule. What does this mean? So let's go back to the example of the accused claiming that he has a mental health defense. Okay. He says that he is suffering from a particular psychiatric condition that prevents him from understanding what he's doing. If the expert confirms that this is the case, that this person is indeed suffering from this condition, on the basis that he had examined this particular witness, the accused, looked at the symptoms and compared them to the DSM. The DSM is the diagnostic statistical manual used by many psychiatrists in the US and around the world to classify mental illnesses. So he looks at the DSM and he says, okay, you have all these symptoms and characteristics. And having looked at you, yeah, I think that you have this particular mental condition. What's the basis rule got to do with this? If you notice, it is possible to make the argument that the DSM, the Diagnostic Statistical Manual that the psychiatrist refers to in his diagnosis, is hearsay. Right? Because the person who wrote the manual is not going to be in court. In fact, the manual is not written by one person, it's written by a whole bunch of psychiatrists who revise the manual quite often. But what the basis rule does is that, okay, fine, that may technically be hearsay, but because that DSM is a bit like a textbook, it's reliable, it's written by experts, so we are just going to look past the fact that the DSM itself could be hearsay and focus instead on what the expert can bring to the table. On the other hand, if the expert did not even personally examine the accused and just learned about the symptoms of the accused through secondhand knowledge, then the basis rule would say that, okay, you cannot violate multiple exclusionary rules at the same time. You cannot violate the hearsay rule and also the opinion rule because you need to personally examine the accused at minimum. Okay, so the basis of the expert's opinion should not violate another exclusionary rule unless, right, it's something like the DSM that's general hearsay rather than specific hearsay. So that's okay. And then there's the ultimate issue rule. What this rule means is that to what extent can you allow an expert to take over the function of a court? The answer obviously is no, the expert should not take over the function of the court. But quite often, it seems like they might be doing that. So we go back to the example of an accused claiming a defense that negates his mens rea. If he succeeds in proving that defense on a balance of probabilities, he will probably be acquitted. Okay, but when I say probably, because it means that for certain kinds of mental defenses in Singapore, if the prosecution fails, it doesn't mean you're acquitted. It means that you would be committed to a mental institution. Okay, but the point is that he will not be found guilty. Isn't it fair to say that the psychiatrist who is testifying as to whether or not this person can argue their mental defense is effectively answering the very question that the court needs to answer? Right? Because it's not just a fact that the expert is being asked to testify about. It is the very fact that will determine the outcome of the trial. That's why it's called the ultimate issue rule. So how the Singapore courts have resolved this is to say that, well, it's not that the experts cannot testify on the ultimate issue, but ultimately the judge has to decide if the expert is credible. So the judge may not have the expertise of the expert, but the judge can still think about whether or not the expert makes sense, whether or not the expert has conducted his research properly, whether or not the expert is clearly contradicting other pieces of evidence that may exist for the crime. But perhaps the most difficult issue that the courts have to grapple with is when experts disagree. So let's work from the ground up. The whole reason why you need an expert to begin with is because you don't know the answer. right? A court does not know if an accused has a psychiatric condition. A court needs an expert to do that. So the prosecution will find an expert and the accused will find an expert. And as is often the case, each of these experts would say different things. The expert for the prosecution will say, no, this person does not have any psychiatric condition. The expert for the accused will say, yes, this person has a psychiatric condition. So how should the courts decide who is correct? So this is very tough because, again, the whole reason why you need experts is because you don't know the answer. And how will you know any better if people who supposedly know the answer are disagreeing? So what have the Singapore courts done? They have said that the courts really have three options. First option, you can decide that both experts are talking nonsense and you reject both of them. And you say they're talking nonsense not because you know better than them, but because, perhaps whatever they are saying don't add up. It doesn't seem to be based on sound principles, doesn't seem to cohere with the other pieces of evidence. And what happens if both experts are thrown out? Well, whoever is relying on the expert loses the case, right? So if the accused is trying to show that he has a psychiatric condition, but the prosecution has managed to produce enough evidence to convict him, then I guess the accused will be found guilty. The second option is that the courts can choose to believe one expert more than the other. Okay? And again, it's not because the court knows better than the expert, but it's really a question of credibility. Which expert looks like he or she knows what is happening? So again, they'll look at credentials, experience, the consistency of the testimony, whether it adds up, right? How does it compare with the other pieces of evidence in the puzzle? So the second option is supposed to be the option that courts are expected to take most of the time. There's a third option, but this is the option that the courts should never take, which is the courts coming up with its own theory. In other words, the courts are just going to ignore the experts and impose its own opinion. So again, we go back to first principles. The first principle is that the only reason why you need experts is because you need help. It doesn't make sense to say that I need help, but then I'm going to solve the problem myself. At the end of the day, I'm going to ignore both. Okay. Now, in civil cases in Singapore, this problem of conflicting expert testimony has largely been remedied because in civil cases, under the rules of Court 2021, you no longer can have your own expert. As far as possible, the parties are expected to agree on one expert. So that's the first obstacle that the courts pose for litigants. The second obstacle is that not only must the parties agree on one common expert, the court must approve of the expert. So if the court says, no, I don't think this expert is good enough, then the parties will have to find another one. So this is considered quite radical because at the end of the day, Singapore is still a common law system. And the function of the common law system is that in the exercise of your adversarial rights, you should be able to choose who's your own expert. You shouldn't be forced to agree on a common expert with the other side, nor should you be forced to accept the court's appointment of an expert. But that's for civil cases, right? In criminal cases, I'm not sure they would follow the same approach. The justification for forcing parties in civil cases to really agree on one expert is to save time and save money, right? And that's quite a Singapore thing to do. When you can save time and save money, Singapore will say, let's do it, right? Or if you can control crime, Singapore will say, let's do it. Okay, I'm mindful of the time. I think I'll try to leave about 10 minutes for questions, so I'll wrap up in the next 5 minutes. We have looked at hearsay, similar fact, opinion, evidence. The last category of exclusionary rules we'll look at is improperly obtained evidence. And this is not that straightforward a category because unlike the other three exclusionary rules, hearsay, opinion, and similar fact, there is no provision in the Evidence Act that deals with improperly obtained evidence. There is, however, a class of provisions that do govern improperly obtained evidence, and that's found in the Criminal Procedure Code that we saw last week. Right? If you do not record a statement properly, if you subject a person giving a statement to involuntariness, then that evidence is considered illegally obtained because it doesn't comply with the Criminal Procedure Code requirements. But what happens if you have entrapment? So we are talking about substantive illegality here. And what is entrapment? Imagine that I'm a police officer and I'm trying to catch someone buying drugs illegally. Instead of going out to find the evidence of that, I go undercover, right? So I pretend to be a police officer. I pretend not to be a police officer. I pretend to be a seller of drugs. I go outside a club in which many people frequent, and I start offering to sell drugs to some people. Some people reject me, but then there are people who accept. And they ask me how much. And I say, I quote them a price, and then I give them some pills after that. So I've trapped them that way. Now, in many countries, that will be considered illegal, right? You can't catch criminals by committing a crime, right? You can't set up a shop and sell, I'm going to sell some drugs. And then when people approach you, you say, got you, right? Because this will be considered using illegality to procure procure evidence of another illegality. But in Singapore, perhaps as a consequence of being very much in favor of crime control, the courts have held that there is nothing wrong with entrapment, at least in the legal sense, right? So if you are caught by the police through entrapment, there is nothing you can do about it. The evidence obtained by the police would still be considered valid. It will not be excluded. Another example would be, let's say, you run a business, but you have a side hustle. Your side hustle is perhaps selling certain things on the side illegally. So it may not be drugs. Maybe let's say certain stolen goods, right? Police approaches your shop. They don't tell you they're police. They're pretending to be normal customers, and they say, "Hey, I heard that you sell stolen goods. Uh, can we take a look?" So you think that these people are real customers, and you show them the stolen goods, and that's where the police arrest you. So they've also induced you to commit a crime, but again, the Singapore court say there's nothing wrong with that. There's nothing you can do about it. So regardless of the type of entrapment, it seems that those evidence obtained pursuant to it would be admitted. But how about simpler things like not following due process? And I think I touched on this last week as well. In many jurisdictions, if you want to enter the house of somebody and you're the police, you need a warrant, right? The police can visit you, but they can't just enter your house with no good reason. And usually, to have that good reason, they need a warrant, right? Or they need some basis to believe that you might have committed a crime. If you have none of those things, they just can't enter your house. So the position in Singapore is a bit unclear. What we do know is that in other jurisdictions like the US, if you obtain evidence that was on the basis of an unauthorized search, so in other words, let's say without a warrant, any evidence that you obtain from that unauthorized search will not be admissible. And so it doesn't matter how probative the evidence that you obtain is, but it will not be admissible because they have this thing called the fruit of the poisonous tree doctrine, which is to say that once you have committed an illegality somewhere up in the chain, it affects and flows down at all the other pieces of evidence that you obtain as a result. So it's a policy decision in the sense that they don't prioritize crime control to the extent that Singapore does. They respect due process, right? So due process does mean that you could potentially shut out relevant evidence. In Singapore, as I said, the position is not so clear. There has been no case yet, amazingly, after almost 60 years of more than 60 years of independence, right? We've not we've not devised any tests. So does that mean that evidence that's obtained pursuant to a lack of a search warrant will be admissible? Not that clear. Some people will say yes, some people will say no. But the technically correct answer is that we don't know. The courts have never decided this, and there's no statute that governs this matter either. Now, if it is a civil case, based on the same rules of Court 2021 that I referred to earlier, the court has the power to stop the use of such evidence. But that same power is not provided in criminal cases. So you would think that if you can stop the evidence in civil cases, you should be able to stop it in criminal cases, right? Yeah, but again, the strictly correct answer is that there's no case yet, so we don't know. Okay, lastly, before I open up for questions, earlier I had talked about how the courts, for similar fact, have reduced the admissibility inquiry into a probative value versus prejudicial effect exercise. But the courts have also clarified that prejudicial effect just refers to whether or not there's enough probative value. And that's for similar fact. Then when we looked at hearsay and opinion evidence, I mentioned that in both situations, the courts have a discretion to exclude evidence that may be admissible using the test of interest of justice, which, as the courts have explained, refer to things like reliability, relevance, good faith. But those are all evidentiary rules that have a basis in the Evidence Act. Since improperly obtained evidence does not have an express basis in the Evidence Act, maybe the courts have some discretion that is not tethered to the Evidence Act that can help exclude evidence that is improperly obtained. So they could take into account a broad range of factors, not just the probative value, but maybe even whether or not the rights of the individual might have been violated. And you can see how in entrapment or in an unauthorized search, the rights of an individual have indeed been violated. But so far, our courts have not gone so far, right? So this still only remains a theoretical possibility. Okay, so I will stop at this point and I'll answer the questions that have turned up in the chat. There are actually a couple more points relating to privilege, which I will leave you to read at your own leisure. Okay, privilege really has more to do with whether or not a witness can be compelled to either testify or to provide documents. And what you want to look at is Section 128 of the Singapore Evidence Act. And in the last slide, there are some other readings that I have written before. These are all freely available. If you Google any of these bullet points, you can find them on the website and you can read them for free. So let me now deal with the questions. Okay, let me stop screen sharing first. And let me see. Okay. Just give me a moment to read the first question. Okay, this question is from Kennedy. So the first question, in the Misuse of Drugs Act, if a person is deliberately framed by another person by secretly putting diamorphine into his pants, can the framed victim be subjected to Section 14? Yes, but he will need to, it's not a lost cause. He will need to be able to explain, if he can, how the drugs came into his possession. So the difficulty is if he really doesn't know, right? If he really doesn't know, then I'm afraid he probably can't rebut the presumption. So that sounds like a pretty scary prospect, right? Imagine you come to Singapore and there are drugs found on you and you have no idea why the drugs are there. Does that mean you get a death penalty? Well, I like to think that the system is a bit more nuanced than that. They will look at all the facts and they will also consider whether or not you have a history of drug trafficking and things like that. So, I mean, because this law would apply perhaps more to Singaporeans than anyone else, because the Singaporeans that go through the airport the most. Yeah, so even though the presumptions may seem quite harsh, I think in deciding whether to prosecute, they'll really look at all the facts of the case. They'll see if you're a credible witness. You know, do you really not know what these things were on you? Which is why, you know, when you go to the airport, they often check with you, right? Can you confirm that you know what the contents of your luggage? Did anyone tamper with it? Things like that. Second question by Kennedy is on hearsay. Does hearsay in Singapore law provide legal certainty, fairness, and expediency explicitly? Yes, because Section 32(3) refers to interest of justice. And even though that acts as an exclusionary discretion, to keep out evidence rather than to bring in evidence. What the courts have said is that Section 32(3) should not be used all the time. So to me, that's another way of saying that as far as possible, you should allow in hearsay evidence because that's what they wanted when they amended Section 32. Third question by Kennedy is indirect proof effective in proving multiple crimes committed by in two different territories? Well, if you're talking about territory that exceeds Singapore, then there may be a jurisdictional question because most of our crimes are territorial in nature. But let's assume that you mean to say that committed in two different places. Well, there are no real limits as to how the Singapore courts can use indirect evidence. So as long as the indirect evidence collectively paint a picture that seems to show that a person has committed a crime beyond a reasonable doubt, then I think that's fine. Okay, next I move on to Rifki Ananda's question. How does the digital age and prevalence of social media impact the concept of hearsay evidence, considering that information is often disseminated and shared rapidly online? Yeah, it does pose a challenge, right? Because there are so many things on the internet now, right? Whether it's forums, social media, or even just chat groups. People are saying all sorts of things all the time, and sometimes you don't even know who these people are. And I think at this point in time in Singapore, the courts are particularly cautious about using evidence that cannot be tested, right? So if you want to take evidence from the internet, you would probably want to find the person who made those statements and cross-examine the person, or at least provide an affidavit. Because even though Singapore is now taking a very relaxed view to hearsay, it doesn't mean that anything goes, right? Even if it does mean that the evidence is admissible, the court can also give it less weight, right? Because if you look at what I was referring to earlier about how when it comes to documents, a lot of things are admitted. If you look closely at the language of Section 32, what that provision is thinking about is really documents that are generated in certain established, reliable contexts. For example, documents of a business are presumed not to be fraudulent. They're presumed to be, kept properly. Documents from government records are definitely considered to be reliable by default, or documents by institutions, so hospitals, the military. These are all considered to be presumptively reliable. So they are not 100% reliable because you can rebut the presumption. But as a starting point, they are considered to be proper. When it comes to internet content, maybe it's the opposite, right? Depending on where you get the internet content from, there's always a presumption that, or an assumption rather, that the contents could have been exaggerated, edited, or there could even be deepfakes. Okay. All right. Next, I move on to Karina's question. His question is that if the evidence of the statement is obtained from hearsay, is the statement within an exception from the exception to the hearsay rule? For the truth. Yeah, I think Singapore doesn't have that technical a view on what hearsay is. If we follow the old English approach, the answer to your question is that the evidence would not be admissible. But because we now have Section 32 of the Evidence Act, that's very facilitative. That allows a broad range of things to be admitted. So I think the courts would not be so much concerned with who made the statement or what is being said, but rather, is the evidence reliable in some way? Can the evidence be tested in some other way? If the answers to those questions are yes, then I think it's still quite likely that the courts will admit the evidence. Okay, so those are all the questions in the chat. If there are any other further questions, I'm happy to take them.
Ada pertanyaan yang lainnya? Any question from you, student? If you want to directly ask the question, it is a place to welcome you to ask the question. But if not, then we can close this class. It is the last class with Prof. Chen Siyuan. Ibu Rafiqoh, cukup?
Yep.
Unmute, Bu.
Itu ada satu lagi, Bu. Dari Joseph Teguh. One
Ada
question.
pertanyaan lagi nggak, Bu?
Iya, di kolom chat ada satu.
Yang terakhir di sini hanya masuk, Prof. Chen
Joseph.
Siyuan, there is a question from Joseph Teguh.
Yes. Okay, how does the high threshold for admissibility under Section 15 ensure that similar fact is only used to prove mens rea and not as mere propensity evidence? Okay. Yeah, I think that the thresholds are indeed only found in Section 15, which requires a series, right? So a series means more than one act, more than two acts, probably at least three acts. That's the first safeguard. The second safeguard is that they must be rather similar occurrences, right? If you look at illustration A, it's not just the fact that he might have done a similar act before, but it's the same modus operandi. Immediately after a fire, he changes house, he collects a fire insurance, he gets another fire insurance, he goes to another house, same thing happens. So you basically only have two options. You either think that all of this is a coincidence, or you think that in all likelihood he intended to burn down his houses. So I think the safeguards are inherent in the bars in Section 15 itself. Now, the only safeguard it doesn't provide is this idea of a broader meaning of prejudice. But because the Singapore courts have never entertained that, we are left with really how similar is the evidence, rather than could there be other normative considerations. Yeah.
Okay, I think it will be it is the last question that in our class, Prof. Chen.
Okay,
And
thank you very much. Yeah.
we are very thankful to have your class, Prof. Chen. The lesson that we have today is very interesting and provided more understanding about criminal law. Especially the examination of the criminal cases in the court, also like the narcotic and etc. And how about the hersey? Then I think it's a little bit common in Indonesia, but in Indonesia we can call it as information from the community. So we don't know exactly who is the prime actor, but it is. Thank you very much. And would you like to have a one sentence to the sentences is Indonesian way to close the class?
Right. Well, really nothing much more than to just thank everyone and Dr. Rosmalinda for extending the invitation for me to teach to this group of energetic and bright students. I hope you learned something from the last two classes. And I think you can find my email address very easily. You just Google my name, SMU, and I'm happy to answer any questions that you may have. If you ever visit Singapore, let me know. We'll be sure to welcome you.
Thank you. Thank you very much, Prof. Chen Siyuan. And in 2024, we are planning to have to sign the MOA. Then we will do a more than this year. It could be a research collaboration, Ibu Rafiqoh, in the criminal study. And I hope we can ask the students to collaborate with us. Thank you. Finally, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Prof. Chen.
Thank you. Goodbye, everyone.
Thank you. Saya tutup ya. Saya lip. Terima kasih Ibu.
Yuk.
Terima kasih Prof.